House Judiciary Committee this Thursday afternoon, May 1st. And we are privileged to have Justice Reiber here this afternoon to weigh in on H-193. And I believe this is the first time that you've been in front of us this biennium, and I feel bad that it's taken us so long to get here. So welcome, Justice.
I know you're busy, and please don't. You don't have to say that. It's a privilege for me to meet with you. I really have tremendous respect for you, Mr. Chair, and also for the members of your committee. I know you all have a lot on your plate, and it's certainly a privilege for me to have an opportunity to talk to you this afternoon.
Great, excellent, and I believe in particular, Coach reached out to you, and
yes.
You've talked to him about the Child and Parent Legal Representation Task Force, and certainly wanted to hear your viewpoint on that.
Well, to the extent that I want to be careful about choosing my words. I certainly have had a very native interest in this subject matter for a long time. When I came on the court over 20 years ago now, I never had a practice in family court. But after I got my feet wet, so to speak, and began to understand the complexity of the cases, the difficulties that parties face in these matters, I got religion, so to speak, about this area. These cases are very, very difficult. They are not easily resolved. And one of the things I wanted to say to you about why I think your bill going in this direction is the right step to take is because, frankly, the processes that we have in the law in our state, and I've never done a comparative study with other states, which is something I would very much like to do. But it's as I've said to other members of the legislature over the years, it's a very thick process. I have a case I want to cite to you, and I hope you all will have a chance to look at it. And in this case involving two children, one mother and two fathers, there were 5 separate attorneys involved. Believe me, I'm not being critical of people having counsel. To the contrary. But the demands on the system being defined as the courts, the lawyers, the guardians ad litem, the DCF workers, the judges, the staff, the demands to bring this case to a head were enormously difficult, with very good lawyers and very good judges and very good other professionals involved. The case is it's a 2016 decision. And by the way, we issued this decision per curiam. And as I've said in public conferences before, when I've talked about this, you could count the number of per curiam decisions that our Vermont Supreme Court has issued since I've been there on one hand. It's very, very rare. And it is distinctive. I think there are probably many different points of view about why a court would issue a per curiam decision, and perhaps I shouldn't go into that myself, but it is a rarity. That's my point. That it's a 2016 decision. The citation is 202 Vermont 415. The caption of the case is In Re AS and KS. Those are the initials of the children's names. Tom Carlson, who is retired now, was the family court judge. Mike Rose, a very good attorney, was the lawyer for the children. But at a point, there were 5 different lawyers that were involved in this case. And one of the things I wanted to read to you from the decision, and believe me, I am not a judge who, in any measure, believes in telling the court, the legislature, this is what you should do. And I have argued against that on many different occasions internally within the system. I don't think it's our place. We construe the law, but it's not our place to say, here's the decision, you need to do something about it. Having said that, there is language in this decision that talks about the system and the difficulties in the system. And I want to just read some of this to you, if you would indulge me. It says in paragraph 11 of the decision, which you'll see when you look at it, it says, unfortunately, due to the dramatic increase in the juvenile docket and shortage of resources, including judges, lawyers, guardians ad litem, and courtrooms, timely decisions are sacrificed for the required process that we follow under the law. The process that was outlined in the law was not followed here. In fact, it's a case study in how a family with 2 children did not see its interest brought to a timely resolution in accord with the law. Now, there's a decision out of the Supreme Court as well a while ago. I could give you the site, but it essentially says that these statutory time limits are advisory. Essentially, they're not jurisdictional. In other words, they're not time limits that if we exceed them, if we go beyond them, we lose jurisdiction to decide the case. The court has said that it's not jurisdictional, it's advisory. Here in this instance, and this is the bottom line point that I want to make, these 2 kids were taken out of their mother's care, and it was a year before the trial court was able to get to a merits decision. A year. So you essentially had 2 children in some form of foster care with foster parents, I assume, not knowing where they were going to wind up. What their permanency is a big deal, as I know all of you, I'm sure, quite well aware. And it was a year. Now, the law would have had this case resolved within 60 days of the removal of the children. I think I might be wrong about these time limits under the current law, but you get the point, I think. I'm sure. So anyway, I have, and going back through this, thinking about it after Coach called last night and today, in digging out this case, which I have such a vivid memory of, I began to ask myself, well, what the heck have you been doing for now almost 10 years since that decision issued? It's 9 years. And but I will tell you, when Jane Kitchell was in the Senate and chair of appropriations, when Dick Sears was alive and chair of Senate Judiciary, the 2 of them, there's another vivid memory I have, called me over to Dick's committee room at the lunch hour one day, and this is before COVID, of course, and they said, the state, and I think it was tobacco money, was coming into the state. And I remember Jane saying, we want to build a fence around, I forget how much it was, $1 million or $2 million, and undertake an evaluation of the child protection system and get it right. And out of that, Marshall Paul, who I know testified yesterday, would remember, because it was Marshall, I believe, and Brian Grierson and Ken Schatz, who was commissioner of DCF back then, got together as a group to propose some reform. And there was reform that came out of that. And I think there was money that was, if that was the divining principle, and of course it's not, but I think the reform led to some positive developments. But the system continues to be in a position where it needs attention, and it's not for want of good people trying their hardest to bring a resolution to folks who've got these problems. There are many, many tremendous people who are giving their heart and soul to this work. But I have to tell you, one of the major problems is resources. I do think that there may be some structural problems. One of the things, and I don't want to put the cart before the horse, but one of the things I think we ought to be looking at is some sort of regionalization of the effort that is made to address these cases in a more timely fashion. It's not only that attorneys are stretched thin and are obligated in multiple counties. That was one of the reasons for the delay in this AS case. The lawyer they had Tom Carlson had blocked out a 3-hour for a 3-hour hearing up in Franklin County in St. Albans, and everybody showed up except one of the lawyers. And it turned out that the lawyer who didn't get it, they sat for, I don't know what they did for 3 hours, but they didn't take any evidence. They didn't move the case forward. And it turned out that the lawyer who wasn't there couldn't be there because he was in, or she was in, a hearing in another county in another juvenile case that had gone over, had extended beyond what they thought it would. This and the part of the problem is that that there are other resources that are also stretched thin, and that is something that I think it merits a hard look to try to figure out how we can, if so, how we can better balance the resources that we do have against the demands that are there. And I think that is that, as I read the proposal, it seems to me that is, it's a very wide open objective, and I think that is a very fair perspective, and it I've thought for a long time it needs attention. So anyway, I'm happy to and honored to have you think about me chairing it. I would certainly relish the opportunity. Again, I do think it's something that would be very important for the people of the state, in particular for parents and children both. So I'd be happy to answer any questions.
All right, thank you very much for that, Chief Reiber. Questions?
Chief Justice, we appreciate that offer. And, as I've shared with a number of my fellow legislators, it clearly states your commitment to the children and families of the state of Vermont. And, and I say that, with all candor and just, we don't see that often in our lives. And so it's just, it's a special thing for Vermont. So
Well,
we
thank you,
appreciate
Coach.
your support.
Thank you very much. Thank you. I certainly appreciate that.
Any other questions or comments? Angela, go ahead.
Thank you so much, Chief Justice. I just wanted to say thanks for, I really appreciate your framing of this inquiry or project, and a little bit, and, you know, having some additional backstory that this has been something that you and other folks within
Yeah.
the system that you described have been interested in for a number of years. And it helps us, I think, it helps me, given some of the testimony we heard yesterday, to really clarify that this is not about trying to find fault with one or
Right.
another entity in the system. It's not that at all. That it's
Right.
really, I see this as a necessary inquiry, I think is probably the word I would use. And that could truly benefit folks in our state who are as has been described, in some of the most difficult moments and days and what becomes years of their lives.
Yeah.
So I appreciate your willingness to help with that effort.
I really appreciate your comments. Could I make one other comment in respect to that? You know, this issue of timeliness for children is a big deal, and it's one of the things that I never. When I said I got religion, this is an example of how I got there. I remember, this is probably 10 years ago, one of the really terrific GALs in Burlington, a gentleman who was an engineer before he retired, by the way, I forget.
Bisbee.
Yes,
John
yeah.
Bisbee, yeah.
Is he still there? Huh?
He is at Wake Robin. He's
Well-
not at Garden Ad Litem still, no.
Oh, he's not? Well, a wonderful guy. And he once told me a story. He said, you know, I've got a kid who I think was in middle school. He said, this was around February, I think, in the middle of the winter when he told me the story. He said, you know, all of his friends, he's telling me all of his friends are talking about where they're going to go to camp this summer. But this guy is in foster care, and he keeps asking me, well, can I go to camp? Can we schedule a camp? Well, they didn't know exactly where he was going to be. They didn't know if he was going to be back with his parents, didn't know if he was going to be in a different with a different foster family. This is the sort of problem that children face. Now, I'm not, you know, I'm a believer that kids are resilient. I think that's one of the things that has, you know, that those of us that read some of these cases, that's what we stick with, because it can be very tough stuff. But I do think that's true. At the same time, this is an example of why I think timeliness for kids and for parents, for that matter, because you know, they're hanging on tender hooks, wondering the same thing, trying to make plans. So this is an important aspect of it.
Anything else? Thank you very much, Chief Reiber. Really appreciate it. We'll try to get you in earlier next year.
No, I appreciate you a lot. You know, I'm sort of have a relaxed schedule this week, and I'm grateful you took me on Zoom. I was worried I was going to get dropped off. I have connectivity problems, but it looks like it's held together, so that's good.
Well, we can run you through our extradition bill and our miscellaneous bill. It's only up to 37 pages. If you need a little extra work, we're happy.
No, that's all right. I
would suggest
enjoyed the
you
time
run.
with you.
All right, thank you very much.
Thanks a lot. Thank you.
Thank you, Judge Zonay.
So long.
Thanks for coming.
Justice Reiber.
No, I said.
Oh, well.
Zoning.
Oh, I'm sorry. Oh, it's easy. I was there. He was there too.
He hung on because there was the potential for technological difficulties, so I was going to be the liaison for real-time issues about what was going on.
All right, I appreciate all you do, Judge Zone. Thank you very much.
Have a great day.
So
Take care.
I don't think I think people have version 1.2. And I'm going to get you version 1.3, which I can tell you what those changes are. And we're going to have the Chief Justice of the Vermont Supreme Court or designee be the chair. And we are adding relief from abuse petitions, substantiation of abuse or neglect to page 3, line 1, and striking the task force not meeting more than 6 times. I'm only telling you that, we can wait until we have that in front of us to just do a straw poll of whether we should include this on in the miscellaneous bill. So I don't know if I need a straw poll. Does anybody object to me putting it into the miscellaneous? I do not see anybody objecting. So it's version 1.3, Eric, when you get to it.
Yes.
So.
Yeah, and flag it for me.
Okay, so why don't we have you here and at the table to go over so this is scheduled for vote tomorrow afternoon, and I think we are on target. And actually, because this is going to money committees, this is the good news, is that I am told that I really need to get it out for calendar math, which means that we're getting close to being able to be out of here. Still, yeah, right. Still end of May. End of May does seem a long
We're
ways away.
in the month we hope to get done.
Right, but nevertheless, I'm told that they really kind of want to have this voted out either tomorrow or Tuesday, if at all possible. And I think we should be there. But my question for folks is: Do we want Eric to walk through the whole thing again, so we know, or are we tired of hearing about it and we should just hear about the amendments?
It's the amendments.
Okay, well, I just want to.
I think come in, but
Well, no, that's fine. I'm fine with just the amendments too, but I want to make sure.
I make it 1 to 10, so.
Just the amendments then. Thank you, Eric.
Yeah, sure. Good afternoon, everybody.
Good afternoon.
Eric Fitzpatrick with the Office of Legislative Counsel. Here, as the chair mentioned, to walk through the latest version of the annual Judiciary Miscellaneous Bill, which is S-109. You should have draft 6.1. Does everybody have that?
Yeah.
Great.
Before you go any further, we're getting up there in numbers, 6.1.
Yes.
What, that you can recollect in your number of years in the building, what's the highest number you've seen on a draft?
One of my own.
Your own or any, or both?
My own, I'd say it's like the mid-teens. But I think others have had more than me.
Yeah.
So we should look into that. Like, what's the record? Like, that's a good point.
Well, cool.
Put it with your notes on sunsets, and then every year you can.
Right. So I'll ask our staff meeting on Monday. Anyone can recall what the highest number is anyone can recall.
Oh, one that we had in the double digits in our time here.
Yeah.
Cannabis, probably.
It could have been cannabis, or it could have been one of the firearms bills.
The one for myself that I remember, it's funny that you had Chief Justice on because it was the Judicial Restructuring Bill 2009, which I think that's the one I'm remembering of the mid-teens. That was the couple 100-page bill that was restructuring the judicial branch in many different ways. It's back and forth with the court on many times.
We have a short extradition bill that may challenge.
Oh, really? There you go. Keep me posted if you hit the double digits. Well, that one's Michelle, right? Yeah. But there really aren't that many changes to draft 6.1. There's really only a few, and they start on page 32, section 34, which is just a technical fix. You may recall on that one, I think it was Representative Malone who noticed this, which is that the cross-reference was wrong. It was referring to this report that's due back from the court administrator and the Association of County Judges regarding the issue that the committee talked about, county courthouses, capital budgets, that sort of thing. And it just had referred to the wrong section number. It's section 33, not 34A. That had been left over from the language that House Corrections was looking at. So that's all there is in that section. Over on page 33, you'll see there's a new section 36 of repeal. This is the sunset to do with, remember the this is the preceding section 35, which had to do with reducing the number of, or at least reducing the minimum number of hours of community service that have to be performed in connection with a second DUI. So it can be more than 80. Under current law, I should say it's 200. So you have a minimum of 200. Can be more, but 200 is the minimum. And again, it's an either or, can be that, or it could be 60 consecutive hours of imprisonment. So the proposal is to reduce that 200-hour minimum to 80. But the additional section 36 on page 33 is that sunsets in 3 years. So so the way a sunset works is if you do nothing before July 1st, 2028, it goes away, it goes back to the 200.
Yes, that's a quick question, Eric. This would be effective on, I'm lost for words, effective on passing?
Yes,
Yeah,
exactly.
Thank
Yep, you bet.
Yep.
Quick question, just
Yeah, yeah, go ahead. Yeah.
drafting question, I think, or process question. So, if we want it in 2020, whatever, before 28, we'd have to repeal the repeal?
In other words, if you want
We
the
wanted it to
80
remain.
hours to remain. Yes. Exactly. Another option, which sometimes people extend a sunset. They're like, well, we don't really know for sure. Yeah, we want to have a couple more years of data, whatever. You can always do that too.
We've done that.
Yep, many times.
And we have a member of legislative council, as you may know, that keeps an eye on the sunsets. One heck of a job.
As far as we know. As far as
I think you can be comfortable with that.
Okay.
Okay, any more questions on the sunset? All right, so now we're moving on to the Sentencing Reconsideration Working Group. You'll see that's section 37. The membership in the group is expanded in this draft by 2 people. That's at the bottom of page 33. Executive Director of the Network Against Domestic and Sexual Violence, or designate, as well as the Executive Director of Racial Equity. Those are 2 new members of the working group. Additionally, over on page 34, there's a consultation element that's added. So you have this in some of the other working groups in the miscellaneous bill. So some designating some parties with whom the working group would consult. You have the drop LWOP New England. So as we've concluded, that is their proper name, LWOP.
What's the acronym LWOP again?
Life Without Parole. So it's the full, if you think of it, what is the name of the entity? Drop Life Without Parole Law New England. So they would be one of the consulted parties. So would the Racial Disparities in Criminal and Juvenile Justice System Advisory Panel, ACO Vermont, and lastly, the one that was just added today, actually, Impacted Survivors and Families Identified by the Center for Crime Victim Services.
And let me flag that for folks. That was by request of Jennifer Pullman, sent me an email, and then I talked to her at lunch, and she requested that, and it made sense to me, and hopefully, you guys are fine with it. I imagine because we do like to watch out for victims and survivors, so. Yeah, okay, yeah, go ahead.
Yeah, sure. Line 13, you'll see, I mentioned that yesterday, that's a Judge Zone request. The Vermont doesn't have sentencing guidelines, more appropriate to say sentencing practices. The line 16 through 19 is a consolidation of what had been 2 different subdivisions about the powers and duties of the working group. So putting together the fact that one of the things that the working group would consider is the resources and procedures of the judiciary, DOC, Defender General, and sheriffs and state's attorneys. So subdivision 4 that you see struck there isn't actually removed from the bill. It's just folded into subdivision 3. And the new language over on page 35, you'll see this had been some language that the committee had been working back and forth a little bit yesterday. And this is a description of what the committee is looking at in terms of this reconsideration process. So and that language now reads, the manner in which a Vermont sentence reconsideration process could operate and how that process could relate with other post-conviction remedies currently available. So let's look at that in a general sense is what the task force would be doing. The assistance for the working group that had been in the previous draft from the Department of State's attorneys and sheriffs is struck. So the idea that the working group themselves will work out how they want to deal with the administrative assistance issue.
Oh, yeah.
Question. So I noticed that we call this task force the sentencing reconsideration, I'm sorry, the working group, the sentencing reconsideration working group, and that term sentencing reconsideration is used in the heading and A, would we want to just keep it consistent on line 2, page 35 and say a Vermont sentencing reconsideration process?
I defer to the chair on that. That was his choice of language.
And what do you think? Yes.
I think either way is correct. So if you want to be consistent, we certainly can. I don't think it changes the substantive impact.
Like consistency.
All right, sentencing, yeah, since we have to have one more version that adds H 193 anyway.
There we go.
Let's change it to sentencing reconsideration.
Sounds good.
Seems good.
Oh, it says, oh, sentence. Okay.
No, that makes sense.
Gotcha. Got that one. So section 38, this is the family forensic evaluator recommendations that are going to be made to the legislature from the chief superior judge, the director of OPR, and the executive director of the Vermont Psychological Association. Remember, the change here is that you're striking subsection A in its entirety. I think the committee concluded that was sort of the issue that you wanted the report to come back on, and you didn't want to sort of preordain any conclusions. So that's struck from here for now.
So and that gets struck for the version that we're actually going to vote on, I assume.
Correct.
We won't see that it's been struck.
No, this is the way. Enjoy it while you see it now, because it will be gone, and the next one is gone. Yes. All right. Yeah, I include the provisions that are going to be struck because it's a change from the previous version, but then the next time it'll be gone.
Right, not a change from current law, but.
Correct. Exactly.
Yeah.
You bet. And then the rest is all highlighted only because this entire section was not in the bill last time. There's no changes to what you discussed last time as far as the substantive work of what this particular group is going to be reporting by November 1st of 2025. Lastly, the effective date section. This is, I think I did discuss this. This is the idea that, and this has to do with that report from the assistant judges and the court administrator about the county courthouses.
Yeah.
That, sorry, not the report. It's actually the underlying substantive change in the law that requires them to add a number of different things every time they request changes to the courthouse budget. That has a delayed effective date. Doesn't go into effect until July 1st. Report comes back January of this coming year. So you have the report first, and then you're free to make any changes to the other piece before it goes into effect if you think it's advisable based on what the report says. And I think that's it. Yep, that is it.
Any questions on anything on this? So a request of you, if this is at all possible, Eric. Can you get us a version that includes draft number 1.3 of H 193 and the version we would be voting on? Is that still possible that we can get by the end of, the end of today, just so people will have it overnight if they want to read it through either tonight or tomorrow morning, so they're prepared to vote for it?
Yeah. Yeah. End of today being a little bit later.
Yeah. Yeah. Just so folks in the morning or this evening, they'll have a chance to read through it.
Right.
Just what's your hurry to push this through when we're probably going to have even more things?
So I've been urged to pass it out by tomorrow or Tuesday because it's going to both Ways and Means and to appropriations. And it's just the timing calendar math that we're trying to get these things.
All right, thank you.
Yeah. So
Yeah, I think I got a calendar invite from Ways and Means for next week already on this.
oh, fine. So I guess they're
I can spit it out. I think it was Thursday.
Yeah.
And will we get it back after the money clears?
Yeah, if they do anything.
Only if they do.
Yeah, if they do anything, that we'll get it back.
Like-
Otherwise, they'll just concur. They'll have a straw poll vote on it. Yeah. But if they have an amendment, we'll have to vote on the amendment, have a straw poll on the amendment. Which I'm not anticipating, because it should be a quick.
Don't say it.
I wasn't gonna say that, the S word. It should just be quick. No, I wasn't, okay.
I think Ways and Means is only, it's the marriage license fee,
Yeah,
right?
it's just the, yeah,
Right.
and I've presented that, the first thing presented to Ways and Means at the beginning of this year
Oh,
was that, because there's a bill up there.
right.
So anyway, all right, so yeah, I'll definitely let you go so you can do that, just so we all know what we're voting on and have some time to take.
So do you want is this going to be, well, first of all, so the whole thing's going to have to be proofed and edited. So that's going to take a little while, but that certainly will be done by, say, before noon tomorrow, if that's what you're thinking.
Yeah, I was thinking, yeah.
The version you look at, in other words, you could conceivably notice a typo here and there because it hasn't gone through the final editing process.
The content won't change.
Correct, exactly. And do you want the highlighting gone in this next one that you look at, you're looking at for tonight?
I think so, because we should all look at all of them.
Right. So don't highlight the new H193
Yeah,
or
we'll need to.
don't highlight the change from sentence to sensing?
No, I think.
I'll remember
I was
that.
hoping that.
We're probably good on those things, so.
Okay.
On the highlighted version, meaning we're getting off.
Yeah, definitely. Sounds good.
All right, thank you.
Yeah, thanks, Eric. You bet. Take care all. See you soon.
Okay, so I should probably double check with, make sure on 187, just get an idea. What I was planning on doing is the version that folks have seen today, 3.2, and I'm going to ask Michelle to send it through editing, to vote on that tomorrow.
You mean 87?
Did I say, yeah, S87, yes.
Okay.
Thank you. And then S44 as passed the Senate, which, so we'll try to line those three up. Anything else? Just real quick, one more last thing. We want to think of, so I'm trying to figure out next week's calendar. And on Tuesday, I think we'll arrive on our notice calendar, H41, the dead body use of a dead body. And also the confirmatory adoption. They both have amendments to them. So it will be on those calendar on Tuesday. I think on Tuesday afternoon, I will schedule testimony so that we can turn that around quickly.
Can you just walk me through very briefly, like how it works when it comes back?
Yeah, so generally it comes back, it's on notice calendar, and the next day, they're expecting us to tell them what we think, or we can seek a delay, or we can, I don't think, it's not very often that it actually gets recommitted. It doesn't usually get recommitted unless there's something major. Hardly ever that happens, but we just will see delay, but I'm going to try to kind of get a jump on that. And so I'm watching the calendar on the Senate. I'm going to look at the Senate to see which things are kind of coming our way, and also get an idea if we're going to need to take some time. And they did add something to the confirmatory adoption that we're going to need to take some testimony on. And I don't think the other bill will need that much. The dead body of a person bill.
Oh, no, I don't think.
Yeah, I mean,
Anything.
yeah. So we'll just probably need the legislative.
They
council.
voted it out 5-0. I don't think it was a voice vote.
I think that's it. All right, thank you. Adjourned until, one last thing, not adjourned quite yet. I reached out again to Rebecca Turner to offer her I've asked her to let me know by tomorrow morning whether she does want to come back in and testify further on 87. So just, I'll text everybody if in fact she does want to take us up on that. And so therefore we'll adjourn till further notice, either at 1 o'clock.
That would be in tomorrow. That would happen before.
That would be after the floor. No, we do it after the floor because I think tomorrow's going to be a short floor from what I understand.